So, good evening, everyone. I know all the mommy dentists are either at home or at the office still, and I'm really excited to have my friend Tina Martini here. She's a trademarks attorney and kind of give us guidance on some of the questions that we collected in advance. So I just wanted to give a warm welcome to Tina. Thanks for coming on, Tina.
It's my pleasure. Thanks so much for having me.
So
I'm happy to give background about me if you'd like, just to get people a little bit acquainted. So thanks, everybody. So I'm a trademark attorney, as Grace mentioned, and I'm a partner at McDermott, Will & Emery, which is a global law firm, and I'm based in Chicago. And my practice is primarily intellectual property, trademark, and copyright. I represent startup clients as well as Fortune 100 clients, and I represent clients with all types of trademark and copyright needs, whether it's a new business that is looking to protect their brand, or whether they're looking to protect works or different types of materials that they've developed, because intellectual property can cover that as well. I help them protect that intellectual property, both in the US as well as outside of the US. And in the event somebody is infringing rights, or if my clients are accused of infringing somebody else's rights, I help them defend their position against those types of claims as well.
thank you. So I was wondering if we could ask you our first question, which is, should we trademark our office logos? And if so, how do we go about doing this?
Well, I would definitely say that more often than not, you should definitely look into protecting your brand. It's really important that it's a multi-step process. The first thing you'd want to do is make sure that you're not infringing somebody else. And I think there's another question that's coming up where we'll get into that a little bit more. But there are a couple of ways that you can protect your name. Obviously, you can protect it as a corporate name, and that's something that you do through a Secretary of State. And a lot of times there's confusion about protecting a corporate name as a corporate name versus protecting it as a trademark. Just know that they are two different processes, and protecting your name as a corporate name does not mean that you have protection as a trademark, nor does it mean that your name is not infringing somebody else's if you get a corporate name. You can file a state trademark registration with your Secretary of State, and that will give you a state trademark registration and the rights that are afforded by the state you're in with respect to a trademark. The most robust type of protection you can get in the US is a federal trademark registration. And the way you would go about doing that is going to the website uspto.gov, and you could file your application on your own. I always recommend working with an attorney, not because I am one and it's a good thing for me, but it's always good to get the guidance from somebody who is an expert, who is able to walk you through that process.
Thank you. So when you're selecting a name or your brand, is there any homework you should be doing as a business owner before committing to something?
Absolutely. And that homework can look a little bit different depending on what your budget is. But if you're working with an attorney, which I recommend you do, what that would look like is what we call a trademark search. And a trademark search is where you take a look at what other people own by way of trademark registrations, either federally or in the various states. It also looks at unregistered uses of brands. The United States is a country where you don't have to have a trademark registration in order to have enforceable trademark rights. And so what that means is sometimes you can start using a name and you can actually enforce that name even if you don't have a trademark registration. So what a trademark search will do, it'll help you figure out whether somebody else out there has the same name or a really similar name for the same type of business. And so I would always recommend doing that. And if you've got a more limited budget, I'd recommend that you at least do online searching, which I tell clients, at least go to the trademark office website and do some searching through there, and also do some online searching through various search engines, just to see if you can locate somebody else who may have the same or a similar name for your same type of business. But if you have the ability to pay a lawyer to help you navigate that process, that's really preferred because there's a lot of nuance to that type of process.
What is the difference between a copyright and a trademark?
Great question. So a trademark is a brand. Technically, it's a word or a slogan or a symbol that is used to identify a particular company or person's products or services. So it's really how that company or that person identifies what their service offering is. A copyright, on the other hand, technically it protects original works of authorship fixed in a tangible medium of expression. So in layman's terms, what that means is things like artistic works, books, poems, written materials, music, that sort of thing. So movies. So they're all protected under the area known as intellectual property, but they're different facets of what intellectual property comprises.
Got it. In what ways might someone commit copyright or trademark infringement but not be aware that they're doing that?
Well, sometimes what happens is you may start using a brand or a design, or you may develop some materials or some other type of work. And you may not know you're infringing somebody because if you haven't, for example, done a trademark search, or you haven't explored on the internet whether someone's using similar artwork to you, or you haven't done a formal search, sometimes what happens is there may be somebody who is already out there who has adopted, for example, a trademark that is the same or similar to the one that you've got, and they're using it for the same or similar type of business. And that's why it's so important to try to do at least some level of due diligence, like a search, because that will help you figure out what your potential exposure is by using a particular name, for example. And so what's unfortunate is that even if you're not an intentional infringer, that doesn't necessarily help you when it comes to trying to defend your position against somebody who says that you're infringing their rights. When it comes to trying to mitigate potential damages, that's where your lack of an intentionality in your actions helps. But that is often how it happens. That's often how an unintentional infringement happens, is if you don't do sufficient due diligence before you would adopt a particular name, for example.
Okay, that makes sense. But I'm going to take it one step further.
Okay.
Because this thought just came to my mind as you're talking about unintentional infringement. And with dental businesses, there are some names that are very just common, like let's, for instance, throw out in the pediatric dental space. There are tons of dental offices that name their office Dentistry for Children because it's like generic, right? And there's probably, if I did a Google search, there's probably an office called Dentistry for Children in all 50 states.
I would not be surprised. Those words, and that's a great question. When we're looking at the protectability of a brand, it's a spectrum of sorts, meaning that on one side of the spectrum, you have made up words. For example, Exxon, which is a completely made up word, and that's the strongest type of trademark you can have. And then on the other side of the spectrum, Grace, is exactly what you just mentioned, which is what is called a descriptive or a generic mark. For example, trying to name a dog like a pet shop, and not having anything distinctive about it. So those types of names are generally, at least out of the gate, considered unprotectable or entitled to very little protection. And so my general recommendation to clients is to try to develop as distinctive a name as you can, because from the very beginning, well, first of all, it makes it less likely somebody else has taken that name first.
Mm-hmm.
Second of all, if you ever have to go after somebody who's using the same or a similar name, you have an easier chance of doing it successfully, even at the very beginning of your use of the name, because it's so distinctive. But if you have a more descriptive name, it's a lot tougher to enforce those types of names usually. Now, sometimes over the course of a few years, you're able to develop what we call acquired distinctiveness or a level of fame in the name, in which case what is a descriptive name at the beginning can become something that is more well-known and easier to protect. But sometimes that takes a lot of effort in order to be able to do that.
Great. Okay. Thank you.
Sure.
All right. Next question. What type of information or documents are needed when applying for a copyright or trademark?
So let's take a trademark first. So you can file, let's assume that you're filing a federal trademark application. What you want to do is you want to go to the PTO website, and then this is assuming you're not having a lawyer do it for you, but if you do have a lawyer doing this for you, this is what they would do. They would go to the uspto.gov website, and they would go to the part of that website where you're able to file a trademark application. There are a couple of initial questions that you need to answer. The first is whether you're filing it based on an intent to use the mark in the future, or are you filing it based on your current use of the mark? Second, you need to identify yourself or whoever the owner of the mark is going to be. You need to identify the mark itself. You need to give your corporate address. You need to, if you're filing it based on use, you need to file, you need to include in the filing the actual date that you first started using it in commerce in connection with your services. And then you also need to, if you're filing it based on use, you've got to show a sample of use as well. And then you will need to sign it. There's a set of statements that you need to attest to, and then you need to sign it. So it's a pretty easy process, and it's one that has been done online for many years. And then the copyright's really not all that different. Obviously, it's a different subject matter, but you can go to copyright.gov and you can file a copyright application. The form is based on what type of work you are trying to protect. You are usually asked to demonstrate a copy of what the work is and provide a bunch of different type of information similar to a trademark: ownership, when it was first distributed, when it was first published, that sort of thing. So it's relatively easy, and it gets easier year on year.
Great. My next question kind of ties back to the other question, which was, how concerned do you have to be if your name is used by a different dental office out of state? Like, at what point does it really matter if, let's say, again, I'm going to use another kind of generic, like pediatric dental office name, Growing Smiles. You know, for me, because I'm the administrator of this 7,000 plus group, I have to vet everyone, you know, and make sure they're working somewhere. And I try to look for websites. And I think I have seen like 20 offices called Growing Smiles across the country.
Mm-hmm.
So like, at what point does it matter? Do you have to be concerned about it?
You know, that's a great question, and it's a bit of a complicated answer, and I'll try to make it as easy as possible, and I'm happy to answer any follow-up questions. So let's take two scenarios. The first is you don't have a federal trademark registration. You're just using the mark in your particular geographic area where your business is, and your business is pretty local. So let's pretend for a moment it's in Chicago, and you don't have a federal trademark registration. And then you find that somebody in Atlanta, for example, has the same name. Ultimately, the critical question is whether there is a likelihood of confusion between your use and this other person's use across the state lines. So if your business is multi-state, it is quite possible that somebody using the same name in Atlanta, for example, could be confused with your name. But it really depends on how well known your business is, and also, are you even doing business in Atlanta? Because at the end of the day, if there's no confusion, there's no overlap in the business, and you don't have a federal trademark registration, then you really can't do anything about it. And this is a very simplistic analysis, and it's a very fact-specific analysis. And what I'm saying is by no means a replacement for going and speaking to an attorney if you find yourself in this position. But trademark rights are geographic in nature. And if you don't have a trademark registration, what we really have to do is take a look at what the geography of your use is. So let's pretend for a moment that you do have a federal trademark registration. And again, this person in this other state ends up starting to use the name after you started using it, and you have a federal trademark registration. Technically, you can send them a demand letter and say, you've got to stop using my name. The issue, though, is that there is pretty settled case law on this point that if your business is not going into this person's geography, you're not advertising there, you don't have clients there, then it's very difficult to get somebody to stop using your mark until you enter that person's geography. So taking the Chicago-Atlanta example, say you're first in Chicago, you have a federal trademark registration, then somebody in Atlanta starts using the same name afterwards or a very similar name. Until you are actually in Atlanta or in the same sort of geographic area, you're going to have a hard time stopping that person from using it because of what's known as the Doughnut rule. And it's a very famous trademark case, and that's what that case stands for. So I'm sure there may be some follow-up questions about that. It's a kind of a strange, quirky part of trademark law, but when you think about it from the perspective of what is the trademark law trying to achieve, it's trying to help avoid there being confusion. The thinking behind that case is that you can't really have confusion unless you've got folks that are doing the same thing in a way where people are actually getting confused. And so that's why, even if you have a federal trademark registration, courts won't really give you a remedy until you're in the same geography or one where it's close enough that it's causing confusion. Does that make sense, Dr. Grace?
Yeah, it totally makes sense to me. I mean, yeah, it's very clear what you're saying. And I think it makes perfect sense. My next question is, if you're adding to your logo, so let's say you start with just like the words. Let's say, like, for example, I'll take my business. I call it Yummy Dental for Kids. Mm-hmm. And I started off with just Yummy Dental for Kids. And then I wanted to add my avatar to it. Or if I wanted to add maybe another word, Yummy Dental and Orthodontics for Kids, do you have to create a whole new trademark because it's like you're adding things or you're layering things, or can you just layer it all in?
That's a great question. I'd say it sort of depends on what you're looking to do. If what the question relates to is in terms of filing for a trademark, like let's say for a moment the question is, if I have filed a federal trademark registration for the original version and then I've added a word or two or added the avatar, would I need to refile in order to have federal trademark protection for the whole thing? The answer is yes. There are certain times where the trademark law and the trademark office will let you amend your existing registration to delete certain matter or to add matter. But that's really sort of tough to do. Usually there's more often than not, the answer is no. And this is where consulting with a lawyer would be very helpful. There's certain types of words, like generic words, where if you delete them from your registration, you may not have to refile. But sometimes adding like an avatar, that is considered a material alteration of your original mark. And so you would have to refile. My advice also is that in addition to considering whether or not you'd have to refile, for example, that you also consider searching again. So say, for example, you filed for Yummy Dental, but then you added and you searched for it, then you filed for it, then you add a nice distinctive avatar after that. That's considered a logo, and that would be the type of thing that I would recommend you do a trademark search for. So not just before you file, but before you use it, because your use, even without a registration, your use of an infringing design could end up getting you in trouble. You don't have to actually file for it in order for you to get in trouble. It's just the mere use of it could be problematic.
Okay. So I guess if, because a lot of people, a lot of dentists have a tooth as part of their logo because that's dentistry, right? But that's, I feel like, is something you can't trademark, a tooth.
Well, it depends on how distinctive it is. I agree with you that if it's just a very basic representation of a tooth without much detail, without anything that really makes it original, the trademark office doesn't tend to like that kind of a design. They may say it's functional. They may say it's the type of matter where you're going to have to disclaim it, which means that you're not even claiming any real proprietary interest in it. But if you take something basic like a tooth, and then you create something very distinctive about it, either the way it's shaded, or you add some sort of a dimension to it, or some other type of characterization that makes it very unique, that absolutely could be protectable, and it's something you should definitely search first before filing. But that would definitely be something that could be distinctive enough. And really the whole purpose of this exercise is when people look at it, do they identify it with you? And if it's distinctive enough that people can do that, then most likely you'll be able to get protection for it.
Well, I just wanted to share a story because my avatar is very much a part of my brand, and it's all on my window line because my dental office is commercial floor on a very busy street. And the kids all know my avatar is Dr. Yum. And I volunteered one summer at a health fair in the community. And it was on the lot of the WGN news studio because it was so big, because that parking lot's so big. And there was a tent. And I volunteered to do dental school exams. And the people that were hosting me, they had many different vendors come, like dental, to supply the gloves and supply the mirrors and the tools. And I walked in and there was my avatar, almost real life height, cardboard. And on the jacket, they put the dental company's name.
Oh my goodness. That's crazy.
Yeah. And I was like, wait a minute. And the whole community knows that that's my avatar. And I'm here volunteering my time, and they ripped off my avatar, my exact avatar.
So what did you do?
So it turned out that I didn't have the avatar trademarked. There was nothing I could do. And I wrote to that company and I complained about it, and they never responded.
We should have talked.
I know,
we should have talked because just because you don't have it trademarked doesn't mean that it's not protectable. I mean, as long as you have it, you're using it as a trademark, you can actually assert what is called your common law rights against others. And so what I would say is, assuming for the moment, and this is what I believe to be the case based on what you're saying, that you had the prior rights in it, you had it developed, and you had the rights assigned to you by the company or the agency that had developed it for you. Just because you don't have a registration, even if it's not registered with the state or registered federally, you are still able to assert your rights against third parties, because just merely using the brand in and of itself gives you protectable rights and enforceable rights.
So my husband said to me, it's not worth the time and energy to pursue it because it was one day and it wasn't ongoing. So he just said, let it go. So that's what I did. But then I was made sure to trademark it.
Yeah. Well, that's good to hear. So now you've got it protected, and that's, so it makes it, getting the protection serves a number of different objectives. First, you end up being able to say, I've got a registered trademark, here's the evidence. But also, if other people are doing their due diligence before they start using a brand, then they will find your mark and hopefully they will steer away from it because they know that you're out there. And so it's the deterrence effect that oftentimes is what makes a federal trademark registration so valuable. So even getting back to our other discussion about the Chicago-Atlanta scenario, even if you're not in Atlanta, the fact that you've got a federal trademark registration could be really helpful, because if people like the folks in Atlanta are doing any type of due diligence, they'd find your federal trademark registration and they'd say, you know what, we better steer away from this name because someone owns a federal trademark registration for it. So that's oftentimes why you do it too, is that whole deterrence effect.
Got it. That makes sense. I am going to jump in and ask Alicia if there are any questions from the group.
There are not any questions.
Okay, great. So Tina, before we end, is there any case kind of interesting study that you would love for us to know about, or any kind of examples that we should be aware about, what something not to do or something definitely to do?
Great question. I would say it's really, well, here's a couple of just pointers. First of all, definitely I recommend that you do the due diligence before you decide to name your business something. You put so much of your heart and soul into your business, and the name is such an important part of it. And so I would highly recommend that you make the investment to look into whether somebody else is out there using the same or similar name, because sometimes even if there is somebody, a relatively minor tweak to the name could end up being all the difference in the world. So I would recommend you do that. I would also recommend that you look at it as an investment in yourself, and that it's just something that's really worth doing. And that you also, if you find people that you believe are infringing your rights, it's really important to not let it go, especially if it's a scenario where someone down the street, like if you are looking at the area, the geographic area in which you're doing business, and you see that people are infringing your rights, it's very important that you make the decision to look into enforcing your rights. Because if you don't enforce your rights and you let other people encroach your rights, what ends up happening is you will not have rights to protect after a certain period of time. And so the enforcement part, and I think this is where sometimes there's confusion or misunderstanding. People think if you just get a federal registration, that's all you need to do, and then you're scot-free. But if you don't actually enforce your rights and take the money and time to do that, then at the end of the day, you may end up with something that isn't quite as valuable as you think it is. So,
and one last thing before I let you go is, I kind of see different dental offices. I don't know if it's right or wrong. Some offices, they just call it Dr. So-and-so's office. That's the name of it. It's Dr. Jack Johnson's office. And then there's some offices that name the office by the town. So it's for example, Chicago Dental.
mm-hmm.
But then someone down the street will just flip it and say, well, I'm Dental Chicago.
Mm-hmm.
Is that a no-no, or how does that work?
I mean, that's a really great question. And this sort of gets back to what we were talking about earlier, which is the protectability of geographic terms and descriptive names and stuff like that. So Chicago Dental, Dental Chicago, those are two very descriptive words. Not to say that over time they can't become more protectable, but I would venture to guess that they're so descriptive, and there are probably a number of folks within the Chicago area that are calling themselves Chicago Dental or Dental Chicago or the Chicago Dental Group or something along those lines. And the issue is that when you've got really descriptive words like that, it ends up becoming a pretty crowded field. And so what that ends up meaning is if you're one of those who's a Chicago Dental, Dental Chicago, Chicago Dental Group, et cetera, you're going to have a much tougher time stopping somebody else from using a name that is really similar to yours. Could you stop someone who's identical? Maybe, but it depends on a number of other factors. And that's where having a lawyer will help you sort of, sift through what the landscape looks like. But just know, and that's a great, sort of corollary to another point, which is you're putting your heart and soul into your business. Just know that if you come up with a really descriptive name, you're going to have a much harder time protecting it. You may be able to start using it pretty easily, but if someone down the street who you see as your arch competitor is using something that's pretty similar, if you're using really descriptive words, you're going to have a really hard time stopping them. And probably some of the most painful, epiphanies that some of my clients have reached over the years has been in this moment when they choose a descriptive name, they're cautioned against it, but then someone down the street opens up a business with the same sorts of words that are very descriptive, and then they get really upset because they can't really do anything about it because the names are so descriptive.
Got it. Well, lots to think about. Thank you so much, Tina, for taking the time.
Dr. Young?
Yep.
I do have 2 questions now.
Oh, sure.
My first question says, is getting a trademark something you can do on your own, or do you have to use a lawyer? I was a little confused when I searched the system recently.
The answer is you can do it on your own. And it's really a business decision, ultimately, whether you decide that you want to do that. You can get a state trademark registration on your own by going to the Secretary of State's website. There's a portal, I believe, in at most, if not all, the different states and their secretaries of state to do that process. Just know that getting a state trademark registration is not as valuable as one would think, just because they're pretty limited in the rights that you're afforded. The federal trademark filing system is at uspto.gov, and that portal gets easier to navigate as time goes on, and that's something you absolutely can do. You can file pro se. It gets a little clunky. There are a lot of pages on that federal trademark registration filing form, but you absolutely can do it on your own.
Great, thank you. And the second question I have says, if a trademark was denied, when reapplying, do you have to include the prior denial packet application? My office name is Little White Tooth, and a Denver office has Little White Teeth. We are in Arizona.
Okay, so the question I have, and I'm not sure that this can get answered or not, is whether it was whether you filed a federal trademark application for it. It sounds like you might have. If we're talking about a federal trademark application that you filed for and you got denied based on somebody else's filing and you ended up abandoning and then refiling, you do not need to submit anything that indicates that you previously filed for it. All of that is of public record. And so whoever the examining attorney is at the PTO would be able to find that out anyway, and it's something that they would look into. So more likely than not, refiling you would end up in a situation where you might get refused again, assuming that other person's filing is still alive and active. So I hope that answers the question. I'm happy to clarify anything on that.
She did answer and said, yes, it was federal.
Yeah, you don't need to worry about mentioning that you filed previously. One thing I think is important to note is that sometimes an initial application can get denied, for example, based on a likelihood of confusion with somebody else's filing. And then you may decide that you want to abandon the application because you just don't want to deal with it. Sometimes the circumstances change. For example, that person whose registration was cited against you, their registration may end up getting canceled, in which case that could clear the path for a future application that you may wish to file. So I think the moral of that story is it's a good thing to sort of keep your finger on the landscape And if you're aware of others that are out there, either state registrations, federal registrations, sometimes it's good to check up on those periodically just to see if they continue to be an obstacle.
Great, thank you. Those are all the questions I have.
Well, you know what, Tina? If you file a federal trademark,
Mm-hmm.
is it forever or do you have to renew it?
Great question, Grace. So when you file it, you assuming that you prove use, it'll register once you get through the what we call the prosecution of the application. That's where the examining attorney looks at it. You also give third parties an opportunity to object to it. Assuming that there isn't any of that, then you register. You cannot register until you prove use. So if you file based on an intent to use, you ultimately have to prove use of the mark before the trademark office will let it register. Once it registers, between the 5th and 6th year of registration, you have to file what is called a Section 8 and 15 affidavit, which attests to current use of the mark. If you try to seek incontestability, which is the Section 15 portion of that affidavit, what that means is that you're attesting to the mark being in continuous use for that period. And you're also attesting to the fact that that there are no current objections, people challenging the registration or anything like that. The reason why I mention that is, first of all, you do have to file at least the Section 8 between the 5th and 6th year of registration. If you're able to gain incontestability status, it really limits third parties' ability to challenge your registration. So you should do everything you can if you do have a federal registration to file that Section 15 as well as that Section 8. And then the 10th year of registration is where you have to file what's called the renewal. And then in the US, every 10 years, you need to file renewal after that. If you're talking about gaining global rights, say you've got such a great business that you've got global, you're looking for international rights for your business. Different countries have different renewal schedules, but trademark rights do not last forever, at least with respect to your registration, unless you renew it.
Okay, that's good to know. And are you, because the question about can you do it yourself versus an attorney, how much does an attorney cost? Like, what would you say is the average rate for a dentist hiring an attorney to do this for them?
Well, I think it depends on the type of lawyer you're looking for. Sole practitioners and small law firms have different rate structures than a larger firm. For example, I work at a large global firm. We price a lot of things on a flat fee basis or a per task basis. So it becomes, I've filed many thousands of applications during the course of my career. I work very closely with other team members of mine, including more junior attorneys as well as paralegals, who will often drive a large part of the process. And so while I may supervise the process, we have very experienced team members who end up costing a lot less on an hourly basis. But what we charge on a per task basis really does not fluctuate very much at all year on year. And so, really just sort of depends on who you work with. We have an efficiency to what we do just from having done it many, many thousands of times. So it really depends on the type of lawyer that folks in our, viewership and listenership are interested in hiring. But I would definitely recommend that you go with somebody that you're comfortable with and who you feel is knowledgeable enough to do a really good job, and who will be efficient about it and who will deliver value to you.
Okay. And they don't necessarily have to be dental specific. They just have to be a trademarks attorney.
Yeah, no, I would recommend, if you're going to go with an attorney, go with somebody who has experience as a trademark attorney. If they've got experience in the healthcare space, like for example, my firm, very special, has a great practice in the health area, and that includes dental practices. We also do work with many other types of businesses as well. I think what's critically important is if you're going to work with an attorney, you work with somebody who knows what they're doing and who can bring the value that you get by hiring an attorney with experience. So for example, to prepare a trademark application, there are certain strategies that could work to your benefit by working with a lawyer. For example, the way that you craft how you identify your services. It sounds really easy, but depending on whether there are other people out there using the same or a similar name, you may have to get a little bit more strategic with how you describe your services. And then so things like that is where the benefit of somebody who has this experience as a trademark attorney would be beneficial.
Well, thank you so much. I am out of questions. And for everyone who's listening, thanks for jumping on. And Tina, if someone wants to reach out to you, can you give out your email?
Sure, absolutely. Well, you can find me on LinkedIn, Christina L. Martini, partner at McDermott, Will & Emery. You can also find me on the McDermott website. McDermott's website is mwe.com. And I am on the McDermott website, and my email address is C as in cat, martini, like the drink. So cmartini@mwe.com.
Perfect. Well, you can't forget martini.
Holy olive.
All right. Awesome. Well, thanks again. Have a great night, and we'll talk to you soon. Thanks so much. Bye.
Bye.